Hello. We are talking today about the rights of grandparents, not as elderly people, that's another story, but with respect to their grandchildren, and particularly their right to have a relationship and communication with those grandchildren. Because from time to time, of course, it's not a regular and usual situation, but it happens. Because of the parents' divorce, for example, and certain animosity between the families, or because of certain animosity within the family between grandparents and parents due to their family history or something else, some offenses taken through the years, something that one side cannot forgive another for whatever. So there might be some like broken relationship or mistrust, or well, there are situations of drug abuse, alcohol abuse, like criminal past, and so forth. So there are situations, some illnesses, some like family diseases, and so forth, where parents, for whatever reason, do not want the grandparents to have relationship, visitation rights with respect to their children. And in those situations, sometimes grandparents are willing to establish or re-establish or maintain the relationship with the grandchildren. They seek some recourse in the legal system, like citing the Civil Code of Quebec, which mentions vaguely, though, but mentions grandparents in that sense, that they were helping parents, that they have their own rights, and so forth and so forth. The point is that in such a situation, a legal position of grandparents is like not impossible, net, but rather weak for the reason of the way how the law sees the relationship between children and parents. Because, and that's important to understand, the situation, at least in courts, is not treated as a problem of the grandparents' rights, but rather as a situation of the children's right, child rights. Because the principle is what is the best interest of the child. So the court is less interested if this broken relationship between grandparents and grandchildren and parents, children in between, if it affects grandparents. Unfortunately, but that's the reality. For the court, is more important if it affects the child. Because, for example, the child got used to see this particular grandmother or both grandmothers or grandfathers around to play soccer, to just play chess, to discuss something, mm, just sit there around and just read or just be around, being taken care of them by these grandparents and so forth. And for a child, it might be not good, not healthy, disruptive to a certain extent if these relationships suddenly broken. But again, there is an issue of the status quo. So if the court sees that the grandparents were not the part of the grandchildren life for quite some time, and then out of a sudden, and for their own interest, not for the best interest of the child, they want to be present in the life of the child, then the courts probably won't be like that much supportive of this. So having that in mind, let's remember that when we're talking about the best interest of the child, legally speaking, they're parents, not grandparents, like normally, if there was no other situation, legal decision made, so some like public curator involvement, DPG involvement, something like that. So not normally parents are the legal tutors, meaning that they represent their children interests, civil rights, and so forth and so forth. Which means that if a parent opposes to the child's relationship to the grandparent, or especially if the parents are acting together. That is sort of presumed, at least by way of a presumption, that it is done in the best interest of the child because it's in the name of the child. Of course, it's still possible to prove in court that that decision actually is damaging to the child, and therefore, for the sake of the child, the relationship with grandparents should be established or reestablished. But from the beginning, in a regular situation at least, parents are speaking for the child. Of course, in such a situation, the age of the child and their own wishes sometimes become important, because one thing is to speak for a child of 3 years old, 5, 7 years old. Another is to speak for a child of 12, 14, 16 years old, still minor. But judges usually believe better that children of certain age can consciously understand what are their interests and what do they want in terms of their communication with their grandparents. And by the way, even the parents might be in favor of this relationship, but grown up children, well, still minor but rather grown up already, children can be not in favor of that. And in that case, the judge might side with the child, actually, again, thinking of the best interest of the child. Uh, so, if you're in a situation as a grandparent where you wish to have access to your grandchildren and some of the parents, for whatever reason, is blocking such an access, then if you wish to get to the court, you have to think of the arguments from the point of view of the best interest of the child and how limiting the child's relationship communication, even through some online means sometimes, uh, deprive the child from something important. Mm. Ancestral culture, for example, additional language that can be spoken, which is in the best interest of the child. Certain maybe eventually professional advice or advice from some certain professional experience, for example. Or if you were the well, that happens to one of the primary caregivers for the child from the beginning, and now there's disruption because of the divorce, usually. Now, this disruption of communication would affect negatively the psychological state of mind of the child. For that, you'll probably need a psychosocial report and so forth. So, is it possible to establish, maintain, protect this right of communication between grandparents and grandchildren? In court, yes, it's possible, as long as it can be proven that it is in the best interest of the child, not of a grandparent, like not primarily of the grandparent. Thank you and have a nice day.